Okay, welcome everyone. Today's session will be on patent marking, and thanks for joining us. We'll be going over some of the statutory requirements as well as best practices for effectively marking your products. Before we get started, just a couple of quick admin details or housekeeping details. We are recording today's session, and at the conclusion of today's webinar, all registrants will get a link to that to the webinar in case you want to look at it again, or feel free to forward that to any of your colleagues who may be interested. During today's webinar, feel free to type in any questions that you may have in the Q&A box, which on my screen is on the top. There's a little bubble at the top icon, or maybe in yours it may be kind of in the center at the bottom. And don't forget to follow us either on LinkedIn or check out our website at slwip.com. Joel Harris will be our primary speaker today, and I'm your host, Doug Portnow. A little bit about Joel. Joel's been in the intellectual property field for about 20 years, where he's been very heavily involved in managing patent portfolios for emerging companies. He's held senior management positions at companies such as InCube Labs and Rita Medical. He also has law firm experience at law firms such as WSGR and Kilpatrick Townsend, that's the old Townsend and Townsend and Crew. In addition to Joel's extensive patent prosecution background, Joel has actively been involved in managing IP litigation domestically as well as internationally. And before entering the legal profession, Joel was an engineer. He had engineering and management positions at companies such as Guidant, Abbott, Johnson & Johnson, and NASA. Joel's background includes a law degree from Santa Clara University. He also has degrees in chemical engineering and bioengineering from Northwestern and Penn State University, respectively. And I'm a patent attorney at Schwegman, Lundberg, and Woosner. And I primarily focus on medical device and mechanical inventions. So with that, a quick overview of today's session. By the way, we were scheduled for about an hour. However, this session will probably be closer to half an hour or so. So it'll be a quick, short one, but it'll be a good refresher. And today we'll be going over what patent marking actually is. We'll be talking about the statutory basis for patent marking, why it's really important to take advantage of patent marking. And then we'll also get into how you actually physically should be marking your products. We'll talk about some issues with marking that could lead to false liability for false marking. And then we'll wrap things up and conclude with some best practices that we suggest you consider. So with that, I'm going to turn it over to Joel. And maybe Joel, you can tell us why we're here. Patent marking seems like such a basic thing. So why are we talking about patent marking?
Well, first, Doug, I wanted to thank you for the introduction and welcome everybody today. And that is an excellent question. Essentially, most startups and other companies recognize the importance of obtaining patents and devote significant time and financial resources to doing so. However, many are simply unaware of the importance of marking their patented products. This is for a couple of reasons. One, early stage companies primarily focus on the development of products and getting the product launched. They also don't have any pressure to mark the product by investors, unlike obtaining patents. And finally, many of them don't have in-house IP counsel, so they just don't know. Next slide, please.
Yeah, and if I can just interject, I think that's a really good comment that, you know, particularly in my practice where I'm dealing with startup companies that are focused on just developing the technology and there is no product to mark, they sort of forget about, oh, hey, you know, we really should mark product when commercial launch happens. So I think this will be a good refresher.
Yeah, you're right, Doug. So first of all, what is patent marking? Well, it's very similar to federally registered copyright marks, such as the C or the registered trademark symbol. Patent marking basically shows patent protection of products, and it's not required, but it's generally recommended, if not highly recommended. Next slide, Doug. So patent marking is basically synonymous with marking your products with the relevant US or foreign patents that cover the products. It should be on the product, but it may be on packaging or labeling accompanying the product. This is particularly relevant to sterile medical products where the product is packaged inside sterile packaging, as well as drugs and particularly infused drugs where there's really no place to put it on. Then there's also a thing called virtual marking. Basically what virtual marking is allows you to mark via the internet, and it's now permissible by recent changes to the laws, specifically the American Inventors Act, but we'll be touching on that in further slides. Next slide, please. So what is the statutory basis for patent marking? Well, it's found in 35 USC, that's United States Code, section 287A. I'm not going to read through the whole statute here, but just through the portion in red. Patentee or other persons may give notice to the public that the same, which is the product, is patented either by fixing the word patent or the abbreviation pat together with the number of the patent, or by fixing thereon the word patent or the abbreviation patent, pat, together with an address of a posting on the internet. This, in the cases where you can't fix it, this can, or it can't be done, it can be done by fixing it to the package or a label containing like notice. Now, failure to mark means no damages shall be recovered by the patentee in any action for infringement, except on proof that the infringer was notified of the infringement and you continue to infringe thereafter, in which case or which event damages may be recovered only for infringement occurring after such notice. Now, filing of an action for the infringement shall constitute such notice. I'll get more into that in subsequent slides. Next slide, Doug, please. Now, why is patent marking important? First and foremost, it serves as constructive notice. Now, there's two kinds of notice when you're giving notice for patent marking. There's actual notice, and that's where you essentially send a warning letter or a cease and desist letter or an offer to license to the other side. And then there's
the so-called nastygram, huh?
Yeah, that's right. The nastygram, basically, yeah, the threat to sue. And then constructive notice where you mark the product. Now, there's some decisive benefits to constructive notice. The damages basically are normally calculated from the time actual notice is given. But if there's constructive notice, the damages may be calculated from the earlier constructive notice date. So it basically, what it does is it allows a higher damages to be awarded because it starts essentially that on the date that you launch the marked product into the stream of commerce. It also provides notice to the public about IP protection, helps to deter infringement, and helps to avoid unintentional infringement. And there's one other point why it's important too, before we get to the next slide. And that is, if you have to send a cease and desist letter, you essentially start the clock ticking for the statutory statute of limitations in terms of when you must file a lawsuit, which I believe is 2 to 3 years. You don't have to do that with constructive notice. So that's another advantage. Next slide, Doug, please.
Oh, hey, Joel, before we move on, what about if you do send out a nastygram, creating a reasonable apprehensive?
That's another excellent point, Doug, because under that circumstance, then you risk essentially the other party filing what's called a declaratory judgment. And they're likely going to do so in their home court, i.e. Their venue. And so courts usually, not always, but there's a distinct advantage to filing in your home turf because your attorneys are familiar with all the local rules, and they generally favor the local party filing. So you avoid all that risk by doing constructive notice via patent marking. Next slide, please. So in order to take advantage of the deterring effect that the patent marking has, manufacturers should have an active patent marking program. Now, you can do this in a couple ways. It can either be via the marketing folks, or you need to have like a separate department within manufacturing there's usually, in my experience, there's usually a group that handles labeling. So you want to make sure that in the SOPs for that group, or the SOPs in manufacturing, specifically specify putting the patent marking on the labeling or the product itself. Now, in foreign jurisdictions, they have similar patent marking laws. So you need to consider the marking the product. You need to consider marking the product destined for sales outside the US with the relevant foreign patents. But what you want to do is you want to check with your foreign counsel for the local patent marking rules and best practices in those respective countries. Examples of actual notice, as I've said previously, may include cease and desist letters, warning letters, offer to license, an actual lawsuit served on the defendant. Next slide, please. So I just wanted to review with you two examples of damage calculations, two hypothetical examples. So in the first hypothetical, the patent owner, not so smart, does not employ patent marking, and the infringer starts infringing on January 1st, 2018. The patent owner learns of the infringement on June 1st, 2019, and sends a cease and desist letter to the infringer on that date. If the court finds infringement, damages are only calculated from the actual notice date of June 1st, 2019. So the patent owner loses out on 18 months of damages. Now, in the drug industry, that can be a sizable amount of money, as well as other industries as well. Now, the second hypothetical, the patent owner employs patent marking beginning at the product launch in 2015. The infringer starts infringing on January 1st, 2018. Patent owner learns of the infringement on June 1st, 2019, and sends the cease and desist letter to the infringer on that date. If the court finds infringement in this case, damages are calculated from the constructive notice date of January 1st, 2018. So you have no loss of damages. Next slide, please.
Yeah, that's a really good point about, losing damages, especially on some of these blockbuster drugs where they're selling billions of dollars a year. That comes out to literally millions of dollars a day.
Absolutely, yeah.
Yeah.
Absolutely, absolutely.
Okay. And just a quick reminder to our audience that if you do have any questions, please feel free to type them into the Q&A box and we'll address them at that time. Thank you.
So having stressed the importance, the next subject is how to properly mark your patents. Simply marking a product as patent pending, while it's common, is generally insufficient to qualify as constructive notice. It's just good for marketing or hyping the product. In the US, you mark the product with the word patent or the abbreviation PAT, followed by a listing of the applicable patent numbers. Now, you don't want to conceal the marking. It should be very easy to read. Now, substantially all of the patented products must be marked, not just a select few of the products. So you don't want to start out marking maybe at the beginning of the production period, the middle, and the end, to cut corners. You really need to have it on pretty much the entire production line. Next slide, please. Placement of the marking may be adjusted to accommodate for wear and tear. Now, if the product is not suitable for marking due to the size constraints, or in the case of a method patent where there is nothing to mark, marking the packaging or labeling accompanying the product may be an acceptable substitute. Now, simply marking the product packaging or product literature that does not accompany the product, however, may not satisfy the constructive notice requirements. So you want to make sure that you're marking packaging or literature that actually is with the product. Next slide, please. So marking should also be updated to remove expired patents and add new patents or remove patents that do not cover the product. Hopefully, if you do have a patent marking department, they can attend to that. Now, updating patent marking can be costly as it may require tooling changes and reprinting cost or scrapping of old packaging and labeling. The American Inventors Act of September 2011 introduced a way to get around that by means of virtual marking, which overcomes many of the issues associated with traditional marking. Virtual marking is accomplished by marking the product with the word patent or abbreviation PAT, followed by a website address that has all the relevant information. manufacturers, contract manufacturers, and licensees should mark the products they produce. Now, one very important point here is if you license or subcontract the manufacturer of the product, you want to make sure that the license or the subcontract manufacturing agreement specifies that the manufacturer or licensee is required to mark the product with the word patent and the appropriate patent numbers. You may even want to put in inspection criteria that allows you to do so. Next slide, please.
And we have a question, Joel. Question
Sure.
is, for virtual patent marking, do you need to include the website address on the notice? I think you addressed that, but maybe you want to.
Yeah, you do. You do have to include the website address on the notice. So that is important. And one thing you want to make sure of is you have the current website address. So sometimes, you know, your website address may change. So that's, you know, if for some reason the company is purchased or there's a merger and the website address changes, you want to make sure you're vigilant about making sure that the website address is corrected. Next slide, Doug, please. Now here's one example of virtual marking. It's by Medtronic, and it's essentially a spreadsheet which lists their products, their product type, and then they have the particular patents associated with that product, as well as the catalog number. So this is a very useful way of doing it because you can update it very easily. Next slide. Now here's another approach used by Abbott. In this case, it's a stent system for a liver. So here, what they have done is they have all of the patents for the entire system. This is also a very useful way of doing it, and there's advantages because quite often for a system patent such as this one, where you might have 3 or 4 components such as a stent and a delivery catheter, maybe even a guide wire, you may not be completely sure which patent covers which element of the system. But by lumping them all together, you don't have to worry about that. And this was an excellent decision on Abbott's part. Next slide, please. Now, you've all heard of false news, but in the patent world, we've had this for quite a long time. It's called false marking. And this one also finds basis in the United States Code, specifically 35 U.S.C. Section 292A. And I'll just read the relevant portions in red. Whoever without consent of the patentee marks upon or affixes to the use of anything made, the names or any imitation of the name of the patentee, the patent number, or the words patent, patentee, or the like, with the intent of counterfeiting or imitating the mark of the patentee or deceiving the public, shall be fined no more than $500 for every such offense. And importantly, only the United States may sue for the penalty authorized on this subsection. I'll explain more about that in the next slide. Next slide, please. So marking a product with a patent that does not cover the product can also create liability for false marking. One point there is you want to have either outside counsel or your inside in-house patent counsel carefully go over and do a correlation between the patent and the product. It's traditionally done using a device known as a claim chart, where you match the elements of the claim to the features in the product. Other possible examples of false marking include marking a product with a patent number without consent from the patent owner, marking an unpatented product, or marking a product patent pending when there is no patent pending. Now, one critical point there, it's quite often that startup companies and other companies will file what's called a provisional patent. Now, you have 1 year's date from the provisional patent to file the utility patent. You may, under certain circumstances, you may have marked the product with patent pending when you filed a provisional patent. That's permissible. But if you don't file a utility patent, in that 1 year date following, you've got to remove that word patent pending from the product marking. It's also important to ensure that patent marking is accurate. Next slide, please.
And just a quick comment, Joel. So just to be clear, when you're evaluating patents to include on the marking, it's the claimed invention that matters. It's not the disclosed invention.
Absolutely. Excellent point. And
Okay.
it's always the claims, as Judge Giles Rich said, claims are the name of the game.
Right. Okay. And we did have a question. I think you will address this. It's probably on the next slide. But some of the virtual notice pages that we just showed had 6 million series patent numbers on there. Is it important to remove expired patents from your notice? I think you'll address that.
I would say, well, I'll address it now. I would say the answer is yes. So clearly, yes, you do need to remove expired patents from your notice. Next slide, please.
Okay.
So more on false marking. Marking a product with an expired patent is no longer considered false marking. However, it's generally not a good idea. So yes, you do want to remove them. Now, previously, there was a wave of a particular type of suit called a qui tam citizen whistleblower lawsuit, which were filed for false marking of product with expired patents. Qui tam lawsuits permit a citizen to file a lawsuit on behalf of the US government with monetary damages split between the citizen and the US government. Perhaps the most famous case was the Solo Cup lawsuit, which involved false marking of 21 billion drink cup lids with expired patents. The plaintiff asserted that each lid was an occurrence of false marking and the statutory damages based on each occurrence. Therefore, they said there were damages upwards of 10 trillion. Note, by way of comparison, the US economy is about 22 trillion. Next slide, please. And not to keep you in suspense, and fortunately for Solo Cup, the courts eventually found there was no violation of patent marking laws because there was no intent to deceive. And Congress subsequently amended the patent marking laws under the AIA in 2011 to exclude expired patents from false marking. False marking suits can no longer also be filed by the ordinary citizen. Only the government can pursue them. As a result, false marking suits have dropped off significantly. But again, the best practice is to review and update your patent marking just to make sure and to remove those expired patents. This can be done by routine audits of the program that help show that there's no deceptive intent on your part. Virtual marking is far easier to update than changing tooling or reprinting packaging and labeling. So you really want to consider virtual. I think it's an excellent means for patent marking. Now, if the marking is in the tooling, you may want to consider using removable inserts for doing the updates. Next slide, please.
And just to go back to the earlier question about removing expired patents, so you won't be liable for false marking if you have an expired patent, but it's good housekeeping to do that, though.
I think so. I think if you do remove it, you can show they removed it. And I think if there ever is any kind of claim asserted against you, the fact that you removed an expired patent, I think really behooves you quite a bit, because you can say you were on top of things, you had an audit program, look, we removed it, therefore there's no deceptive intent. And there's other instances where in some cases parties can assert that somebody was using their patents unnecessarily or in a very aggressive manner. So by showing you have an audit program and removing expired patents by use of that audit program, I think it really buttresses your case to show there's no deceptive intent or no intent on that part. Next slide, please.
Yeah, and that's a really good segue to a question that just popped up, and I may be able to help you out with this. The question is there any case law that imposes a formal ethical obligation to have formal internal reviews or memo documentation of such claim charting before marking a product in the absence of evidence to deceive?
That is an excellent question.
That's definitely a Joel question.
Yeah, it's a question I would ask. That is an excellent question. You know, I'm not sure. I would have to research the case law and get back to that person. I don't know if you know if there is, Doug.
You know, again, just off the top of my head, I think your earlier answer about if you do have an active program of auditing and updating marking, that goes a long way to your probative value in demonstrating that there is no deceptive intent. But there's two cases that come to mind. One of them was Forest Group v. Bond Tool Company, and the site to that was 590 F.3D 1295. And then the Solo Cup case that Joel mentioned earlier, that was Piconat v. Solo Cup. And I believe, if I recall, the courts did address the fact that the parties involved had patent counsel involved in determining, whether patents were relevant for marking or not. And in other words, they relied on counsel's input into that. So there is again some court opinions that do suggest that if you do these things, if you do claim charting, if you do document some of these things, it will definitely go a long way towards helping you prove or disprove deceptive intent.
Yeah, excellent point. So all the more reason to have an internal process documented, and or either using your own in-house counsel or using outside counsel. So you can, again, establish, as Doug said, no deceptive intent. Next slide, please.
Okay.
So what are some best practices in light of what we presented today? First, your patented products should be marked with the relevant patents that cover the product. Method-only patents may optionally be marked on the product. You want to make sure that licensees or contract manufacturers are properly marking the products with the relevant patents. And again, you want to specify in the license agreement that all licensees are required to mark the product with the licensed patents. You want to maintain records of how products were marked in case there is legal action later, just like other manufacturing records. If the product is unsuitable for marking, you may want to consider marking the product packaging, labeling, or using virtual marking methods that we've described. You want to ensure that the patents marked on the product do in fact cover the product. Claim charting is a means for doing that. You want to routinely review and update patent markings to ensure they are accurate in order to avoid penalties associated with false marking. And you want to seek the advice of patent counsel for guidance on patent marketing. And finally, check with foreign patent counsel for patent marking guidance in jurisdictions outside the US. Next slide, please. Finally, our conclusions. Marking your product with patents that cover the product provides the constructive notice, which may allow collection of higher damages in infringement suits. So that is the principal reason why you indeed want to mark your products. Incorrect patent marking can make a manufacturer liable for false marking, and effective patent marking requires routine monitoring and update to ensure marking is accurate. So I just want to close at, mark my words, if you mark your patents well, all will be well. Thank you. And any questions from the audience?
Yeah, Joel, looks like a question just came in. The question is, does virtual marking require a company to correlate each of its granted patents with a specific product, or is it enough to merely list the patents without tying them to a specific patent?
So a specific product. I think you do need to correlate it to a specific product. Though if you have a system like Abbott did, where there's 3 or 4 products sold together, I think that's okay. But no, I don't think you can take, otherwise you can't take separate products and lump them together and put a whole bunch of patents associated with those products. I think in that case, the courts may find deceptive intent. So you really, I think, need to do a one-to-one correlation, except for system, or except where you sell products as a system.
Yeah, I agree with that. Let's see, another question from one of our audience members. Given internal resource constraints and corporate push to reduce outside legal spend, are there tools that you would recommend that improve efficiency of the process?
There may be some manufacturing software that actually has a process for doing this. Also, it's a possibility that there can be patent docketing software that has a feature that allows you, that basically sends a message about expired patents and current patents where you match those patents to products. So I think the answer is probably yes, but I'd have to research and see what software is out there. But I would think that somebody's thought about this problem.
Yeah, and I think my 2 cents on that is, again, at the end of the day, you've got to look at the claims. So it's going to be a very manual process anyways. But that being said, what I typically suggest to my clients is that they incorporate this patent marking process as part of their quality system, their ISO 9000.
Yeah, and yeah, that's an excellent point. Now, something else when you say the claims, now sometimes claims can be modified due to several aspects of patent prosecution after issuance. One of them is you can have a reissue. Also, if the patent is challenged at the patent office in what's called an inter partes review, sometimes the claim, either the claim will fall or the claim will be amended. So it's very important that if any of your patents are challenged or there's a reissue process, that you go back and you do the claim charting again to make sure that indeed the modified claim matches the product. Now, another approach, just in case you haven't marked, there is another approach for potentially showing constructive notice, and I've seen several companies do this in litigation. That is when a potential competitor is seeking their own patents, they have to file, they have a duty to disclose to the patent office all relevant prior art. And you may want to check to see if they've cited any of your patents. If they have, and they're cited in a form called an informational disclosure statement, or IDS. If they have cited your IDS, then they have cited your patent in their IDS. That's another form of constructive notice. So just a tip for another way to show the other party was aware of your patent.
Okay, good. This is a great question. I love this one. Question is, have you used virtual marking pages for FTO studies?
That is interesting. Interesting question. I'm going to start doing it.
My response is I love this because I think that is a brilliant strategy. It's a great place to start on an FTO study, because if you can find the website that lists all the relevant patents for that product, I mean, that's half the battle right there.
Yeah, that's superb too, because if the other party themselves lists the patents and they don't list other ones, so you right off the bat, So I think that's a great way. That's a great question, very insightful.
Yeah, I like that one. And I have done that once or twice, where if I didn't know where to start, I looked on the manufacturer's website for that patent page, definitely. All right, well, good. And if there are any other questions, please do ask. Otherwise, I think we'll kind of call it a day and wrap things up. Again, Joel, I want to thank you very much for being our guest speaker today. And Michelle, again, thank you for organizing all of this. We just had a question pop up. And Joel, you can answer this one very briefly. What is an FTO study?
FTO is freedom to operate. So generally, before you decide to get into a market, you want to look at all the potential issued patents, and specifically the claims in those patents, and see if your device reads on any of those claims. And by read on, I mean infringe. So you do a careful analysis comparing your potential product to the issued claims. Now, there are different degrees of freedom to operate analysis. One is where you just look at issued claims. If you want to be a little more thorough, you look at pending claims. And if you want to be even more thorough than that, you actually look at the patent specification of pending applications to see if there's support in the specification for any claims that might read on your product. The reason I say that, I've been asked that in diligence a couple times. So that is something you want to consider. But generally, freedom to operate is something you want to do before you launch a product. And if you're a startup company, it's something you absolutely want to do before you start seeking investment, because the diligence attorneys on the other side are going to ask you if you've done it. If you haven't, they're going to immediately discount you. If you have, then it basically puts you in greater stead in their view. And when you do it during, if you ever have diligence, you want to carefully look at the closest patents and have reasons why you don't infringe those two or three closest patents. And that'll really help you out, because it shows to the other side that you've really been thorough.
And that's a whole practice area in itself.
Yes, indeed. Indeed.
All right. Well, good. Why don't we call it a day,
All right.
Joel? And again, thanks for your participation, and thanks to Michelle. And to our audience, thanks for joining us. We hope you found this interesting and informative. If you do have any other questions, feel free to contact us. We'd be delighted to chat with you further. Thanks again, and have a good day.
And thank you, Doug. And thanks everyone out there, and be safe. Be well.